Welcome to EUPrivacyForAll, Session 67 on GDPR, Consistency and Dispute Resolution, Article 57 and 58a. The drafting of a separate Article 58a dealing with consistency and dispute resolution was suggested by European Parliament. However, it was shaped in a really different way compared to the final draft finally laid down. Basically, the lead authority shall share all relevant information and submit the draft measure to all other competent authorities, and serious objections would be the cornerstone of such a process. Even if it remains the cornerstone of such a process, the drafting of the provision of Article 58a was radically different from the one suggested by the Parliament. In the end, based on Article 57 on the consistency mechanism, laying down that in order to contribute to the consistent application of the GDPR throughout the EU, the supervisory authorities have an obligation to cooperate with each other and, where relevant, with the Commission, it was laid down that the EDPB shall adopt a binding decision in the following cases. First, where a supervisory authority concerned has expressed a relevant and reasoned objection to a draft decision of the lead DPA, or the lead DPA has rejected an objection. Second, where there are conflicting views on the lead DPA. And third, where a competent supervisory authority does not request the opinion of the EDPB, but should do so, or does not follow the opinion of the EDPB. In such a case, any supervisory authority concerned or the Commission may communicate the matter to the EDPB. The decision shall be adopted by the EDPB within 1 month, by a 2/3 majority. This period, when necessary, may be extended by a further month. The decision taken will be binding on all the concerned supervisory authorities. Additionally, the Chair shall notify without undue delay the decision to the concerned supervisory authorities, and the decision of the EDPB shall be published on the website of the Board without delay. The lead supervisory authority, or, as the case may be, the supervisory authority to which the complaint has been lodged, shall adopt their final decision on the basis of the decision of the EDPB without undue delay, and at the latest by 1 month. Then, the concerned DPA will have to inform the EDPB of the date when its final decision is notified, respectively to the controller or the processor, and the data subject. Once again, this decision will be published on the website of the EDPB, attached to the decision rendered by the Board. In Recital 105, it is laid down that the consistency mechanism should also apply where any DPA concerned, or the Commission, requests that such matter should be dealt with in the consistency mechanism. That is to say, whenever it will be substantially affecting a significant number of data subjects in several member states, and DPAs would not agree. In Recital 106, it is made clear that the EDPB should, within a determined period of time, issue an opinion if a majority of its members so decides, or if so requested by any DPA concerned or the Commission. The EDPB should also empower to adopt legally binding decisions in case of disputes within supervisory authorities, with a 2/3 majority decision, legally binding, that will be drafted in clearly defined cases where there are conflicting views among DPAs. Currently, the directive lays down in Article 28 on supervisory authorities that DPA is a competent whatever national law applicable to the processing in question to exercise on the territory of its own member state the powers it has. The supervisory authorities shall cooperate with one another to the extent necessary for the performance of their duties. What should accountable data controllers and processors get prepared for? First, knowing that EU DPAs have to cooperate with each other, but also with the Commission, and EDPB will have to adopt a binding decision in 3 cases: whenever a DPA concerned has expressed a relevant and reasoned objection to a draft decision of the lead DPA, where there are conflicting views on the lead DPA, and where a DPA does not request the opinion of the EDPB, and it should, or it does not follow the opinion published by the EDPB. Any authority concerned or the Commission is entitled to request the consistency mechanism, for instance in case of disputes between DPAs. EDPB decisions shall be adopted within 1 month by a 2/3 majority of the members of the board, and this month could be extended by a further one. The decision finally taken by the EDPB will be binding on all DPAs. The lead authority or the authority to which the complaint was sent shall adopt a final decision within 1 month. Both decisions from the EDPB and the competent authority will be published on the website of the EDPB without delay. So the question triggered now is knowing whether the consistency mechanism will bring to EU data protection practical consistency and not delaying, blocking national enforcement mechanisms.